Good morning, sir.
Morning.
You can see and hear me?
Yes.
Thank you, sir. Before we hear from Mr. Christou, I should just say that we will be having the usual fire alarm at 10 o'clock.
Yeah.
As usual, I propose we just sit through that.
Yes, of course.
Thank you. If I can call Mr. Christou.
Yeah.
Yeah.
I'd like to take that in your right hand and then repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth
the whole truth,
and the whole truth
and nothing but
and
the truth.
nothing but the truth.
Okay, if you'd like to sit down.
Thank you.
Please, could you state your full name?
Richard Christou.
Mr. Christou, thank you very much for attending the inquiry today, and thank you for the 2 witness statements that you have provided. I want to turn to those first. You should have a bundle of documents in front of you. Could I ask you to open that and have the first witness statement in front of you?
I do.
Thank you. Is that dated the 20th of March 2023?
Yes.
And that, for the record, that has unique reference number WITN 03840100. Could I ask you please to turn to page 29?
Yes,
Is that your signature?
it is.
Could I ask you then to turn to your second witness statement, dated the 9th of May 2024?
Yes.
And for the record, that is reference number WITN 03840200. Now, before I ask to turn to your signature, there's one correction I believe you want to make, which is at page, page 21. Paragraph 103.
That's correct.
I'll just wait for that to come up on the display.
It's
There we are.
right.
So as I understand it, it's the last sentence of paragraph 103, and the correction should be in Schedule A02 to change the paragraph number to 4.1.8.
That's correct.
And is it the same for Schedule A4?
Yes.
Thank you. With that correction in mind, could I ask you please to turn to page 27 of your statement?
The second witness statement.
The second witness statement, sorry. Yes, thank you.
Yes.
Is that your signature?
Yes.
And are the contents of both of those statements taken together true to the best of your knowledge and belief?
Yes.
Thank you. Thank you very much. Those witness statements now stand as evidence in the inquiry. They will be published on the website in due course. I have some questions for you about them, but not all issues that you raise within them. I want to look at an exhibit in your witness statement first, if I may. That's, if we can bring up the first statement, please, and page 30.
Page. I'm looking at the wrong statements.
Yes, it will be on the screen shortly as
okay.
well. So this is a CV that you've annexed to your witness statement. if we could go to the bottom of the page, please. We see that you qualified as a solicitor in 1969,
Yes,
and thereafter, from 1970 to 1990, you held various roles in the companies listed on the middle column.
yes,
Now, of those roles, were you acting as a in-house solicitor for where it says legal advisor? Is that akin to in-house solicitor?
yes,
And we see from 1982 the two roles you had first with STC Telecommunications and then with Sologlass UK Limited. You acted as company secretary.
that's correct.
And then finally, from 1987 to 1990, it says Director, Commercial and Legal Affairs at STC PLC. Was that did you sit on the board of that company?
No, it was what I describe as a courtesy title.
That can come down, thank you. I want to now look at your roles from 1990 onwards, and from that point you worked within the ICL group.
Yes,
And when you joined in 1990, I understand that Fujitsu, I'll just use the single term without going into the precise legal entities, but Fujitsu was a majority shareholder in the ICL group.
yes,
And ICL at that time continued to have its own branding as ICL,
correct.
but in 2002, the brand changed from ICL to Fujitsu.
Yes,
Could we look, please, in your second statement at page 3, paragraph 10?
yes,
So it's been some time since the inquiry's considered the corporate structure for Fujitsu, so I think it's helpful to go over it. You helpfully here set out the key or relevant companies within the ICL group, and at paragraphs A to E. On the left with the name before the change of brand in 2002, and on the right when it became a Fujitsu branded company.
that's correct. Yes,
So at the top of the corporate pyramid, as it were, we have ICL PLC, which was the ultimate holding company for the group.
yes,
And we see that became Fujitsu Services Holdings PLC in 2002.
yes,
Beneath that at B, there's International Computers Limited, which was a wholly owned subsidiary of ICL PLC.
correct.
International Computers Limited carried out ICL Group's UK operations. Is that right?
That's correct. Yes,
And that became Fujitsu Services Limited,
yes, yes.
which is now or from roughly 2002 onwards, became the contracting party for the Horizon contract.
Yeah, precisely in April 2003 is when the change was made, but yes, now it is.
Thank you.
Yes,
2003, sorry, you're quite right. What we see at C is ICL Pathway Limited. Now, Pathway, when the Horizon programme was being tendered for, that it was referred to as the Pathway programme.
yes,
And ICL Pathway Limited was set up as a company in order to tender for and deal with the Pathway programme.
yes, yes, that's correct.
And that in itself was a wholly owned subsidiary of International Computers Limited.
It started off as a consortium. There were two other shareholders. From recollection, it was Gyro Bank and De La Rue. But shortly after, I think about a year after, 1996 maybe, ICL and the other two consortium members parted company, quite amicably, and it then became a wholly owned subsidiary of of International Computers Limited.
And I think you're quite right. The De La Rue and Gyro Bank consortium was a sort of historic interest, being a PFI deal initially. For today's purposes, from '96 onwards, wholly owned by ICL,
Correct.
Sorry, International Computers Limited.
Correct.
Thank you. And the final company that we see there is D, the ICL Global Investments Limited. Now, I understand that that was a subsidiary of the overall parent company, ICL PLC.
That's correct.
And ICL Global Investments Limited dealt with the ICL Group's non-UK business.
That's correct.
Let's turn then to look at your roles. You were appointed as Director of Commercial and Legal Affairs of International Computers Limited in 1990.
Yes.
We don't need to turn it up, but in your first witness statement, paragraph 5, page 2, you say that you were responsible for the provision of legal and commercial advice in connection with the participation of the ICL Group in the tender for the Horizon IT system.
Yes, that's correct.
So in that role, and when dealing with the tendering process and the Horizon IT system, which teams reported to you?
Only legal personnel, no other persons at that stage. There would have been some commercial people as well, but that's all. There were no operational people reporting to me at all.
And do you recall who operational people reported to?
They would have reported either directly or indirectly, and I think directly to Keith Todd at that stage.
And could you explain where Keith Todd sat in relation to you in the management structure?
I reported to Keith Todd. He was the chief executive.
Now, at that stage, were you part of any management or executive committees within International Computers Limited?
There was a Fujitsu, sorry, it would have been ICL at that stage, ICL Management Committee, I suppose you'd call it, which met once a week, and all of the reports of the chief executive would sit round the table and you discuss whatever matters came up.
And for the purpose of those management committees, was there a hard-line difference between, say, ICL PLC and International Computers Limited?
I don't think people thought of it like that.
say with trepidation that I think that's the end of
We
it.
can carry on.
Just for clarity, I was asking you about management committees,
Right.
and the question I asked before we had the fire alarm was there a hardline difference between the management committees of, say, ICL PLC and International Computers Limited?
As I said, I don't think people thought of it like that. If you look at the composition of that management committee, the people on it, of which I was one, were probably called director of this and director of that, but none of them, except the chief executive, was on the board of ICL PLC. So in that sense, yes, there was a hard line, I suppose. You could call it a hard line between them. But whatever went on there, it was the chief executive's job in due course, as a member of the board, to produce his report to the board.
So in your role, you would attend the management committee
Yes?
every week. You weren't a member of the board of ICL PLC,
No?
but you might be asked to. Would you be asked to attend on occasion?
I actually can't recall an occasion when I was asked to attend.
I've asked there about management committees of ICL PLC and International Computers Limited. What about ICL Pathway Limited? Did that have a separate management structure?
That had a separate management structure because obviously it was originally set up as a consortium agreement. They had their board, and it was managed, I suppose, quite a lot in the early stages via the board. The chief executive would report to that board, but in practice, the chief executive reported to, well, he was called managing director, reported to the chief executive of ICL, who would have been Keith Todd.
Would that mean the managing director of ICL Pathway Limited came to the management committee meetings which you attended for International Computers?
Frankly speaking, I can't recall, but I don't think so. But I don't recall actually seeing him at a meeting.
And whilst you were in your position as the Director of Legal and Commercial, did you attend the board meetings of ICL Pathway Limited?
Yes, I did.
Can you recall who else attended those board meetings, in particular, who from an IT background or an operational background attended?
Let's think. The only one that springs to mind, well, of course, there was the managing director of Pathway, who was then Mr. Bennett. I think Mr. Coombs attended as well. I don't recall any other operational people. Mostly it was a board originally with some of the representatives of Gyrobank and De La Rue, and they actually stopped on for some time afterwards because there were subcontracts with them.
To turn then to your, well, before I do that actually, I should say, in your first statement, you go into as requested by the inquiry, an amount of detail in relation to the benefits agency withdrawing from the agreement. Those were phase 2 issues that I don't propose to cover with you today.
Right.
You became acting chief executive and shortly after chief executive of ICL PLC in 2000.
That's correct, yes.
And whilst you were chief executive, I understand you were also a director of International Computers Limited.
When I was chief executive, I would have been a director of ICL PLC in that sense. I mean, nobody really looked at International Computers Limited as a separate company, whether it's correct or not. It was, if you like, all mixed together. And the board that was, if you like, controlling the whole thing was the board of ICL plc. And yes, I would have sat on that when I was chief executive as a board member.
In terms of the responsibility for overseeing the Horizon IT system, at the time you became chief executive in 2000, and at board level, was that a responsibility of ICL Pathway Limited, ICL PLC, or both?
I think at different levels it was both, because clearly ICL Pathway was executing the contract and looking at it on obviously a day-to-day basis, hourly probably. But ICL PLC, obviously as the ultimate board, had responsibility for the whole business, including Pathway, or Horizon, I'm sorry.
It's quite a broad question, but would you say that the identification, analysis, and management of risk is important to the running of a company?
Of course it is.
And, excuse me, would you accept that ICL PLC, or the board of ICL PLC, was responsible for overseeing how the group or the company, either ICL PLC or ICL Pathway Limited, identified, analysed and managed risk?
Only in the broadest sense.
Could you expand on that, please?
Yes, sure. If you look at a company the size of this, it is not possible for every level of detail to be surfaced to the board. If every single document about every single contract was surfaced to the board, they would not have time or capacity to understand it or to consider it even. So what is necessary is a filter system whereby overall the board has to be satisfied, and this is what I've described in the second witness statement, that there are flows of information in place, but one has to manage by exception, and people further down in the organisation, in this case the managing director and the other responsible people in Pathway, had to deal with day-to-day matters, and levels of a certain granularity, complexity would not come to the board. The board would have certain reports and they will be satisfied with the overall conduct of the business, but precise details, no.
The filters you've described, presumably the purpose of those is to ensure that any serious matters that ought to have the attention of the board, either of ICL Pathway Limited or ICL PLC, ensure that those significant issues make it to the board?
Yes, I think that's correct. I mean, saying ensure they reach the board, provided people further down operate the system properly, then they will reach the board. There were issues that were serious. In my second witness statement, I refer to the red alert system, and those things did come to the board. So details, certain details, would not have come to the board because they were too complex, technical, and too detailed.
Would you accept that as chief executive, you had a responsibility to exercise care to see that those filters were working properly and people in the lower down executive levels were filtering information up appropriately?
I'd accept that I had responsibility to set up the systems. A lot of those systems were already set up before I became chief executive. One has to delegate, and delegation in the organisation requires that people further down make those decisions. It's necessary to see that appropriate personnel are appointed, and at various levels that is always done. I shall point out that all of our employees are required through the HR system to go through assessments as to capability, etc., on a regular basis, and these are filtered up, and if there were any concerns about the competence of a person, the next level of management would have dealt with it. So I think overall I'm responsible, and I accept that, for setting up the systems, but it's people lower down in the organisation who have to operate them.
That's talking about responsibility for ensuring things are working. I want to ask a slightly different question about accountability. Would you accept that as chief executive, you were ultimately accountable for the operations of the ICL group?
I don't accept that. That's too broad.
In terms of your accountability then for the ICL group and its operations, what would you say your level of accountability was?
What I was responsible for was that, as so far as possible, to see that the operations of ICL were carried out legally, were carried out profitably, and to report to my shareholders, Fujitsu Limited, various issues insofar as it was necessary. If you mean that I was responsible for the miscarriage of justice, then I don't accept that. It's not to mitigate the miscarriage of justice, I hasten to add. I think it's a gross miscarriage of justice. I'm really feel for the sub-postmasters and the postmasters who are involved. But talking about accountability is a different matter. And certainly, I knew nothing about it.
I want to... We'll come back to specific facts as we go. Before moving on to look at the restructure, I just want to ask, when you were chief executive, who did you report to?
I will first have apart from the board, in actual fact, I reported to a Mr. Naruto in Tokyo. He was a very senior member of the Fujitsu Limited board, and he was the person who oversaw the purchase of ICL by Fujitsu in 1990. After that, I reported to a Mr. Kurokawa, who was later president of Fujitsu, and I reported to him for a long time. And following that, I would have reported to the next president and the next president.
And in terms of, as chief exec, your reporting lines, who reported to you directly, who had responsibility for the oversight of the Horizon IT system?
Right. Very initially, and I'm talking about the 2000, Mike Stairs, I presume, would have reported to me. From July 2001, a chief operations officer, Mr. David Courtley, was appointed. And from then on, he was responsible for all of the operations within in ICL, as it was then, and all of the operation departments, including Pathway, reported to him. He reported to me. I kept the functional departments at that time, so things like HR, marketing, and legal.
Actually, I'll go slightly out of order because we're on the matter of Mr. Courtley. In April 2004, you became executive chairman of what was then Fujitsu Services Holdings PLC, but had been ICL PLC.
That's correct, and he became chief executive.
You remained employed by the company on a full-time basis, I understand.
Yes, that's why they called it executive. I mean, we know it has no legal significance. You're chairman or you're not chairman, but that's what Fujitsu wanted to use because that's what they thought it meant.
How did your responsibilities change upon becoming chairman?
Yes, they were much more focused outward, dealing, for instance, with particular customers, a lot of them overseas, because Mr. Courtley had his hands full reorganising and dealing with the operational divisions within what was then International Computers Limited. So, to give you a small example, I went with the president to Russia at one stage to look at their operations there. I went to Finland. A bit later on, I was on some boards of Fujitsu America and so on. I mean, the role grew much more widely.
And the functional elements that you said you kept when Mr. David Courtley became Chief Operating Officer in July 2002, did you pass those functions down to Mr. Courtley?
Yes.
Yeah.
Sorry, I shouldn't cut you off. Yes, the answer is.
Well, I was going to say when you became executive chair.
Yes, exactly.
What was your working relationship like with Mr. Courtley?
Very good. I'd known him for some time, actually. He worked previously for EDS, and we first came across each other in a kind of contract dispute between, as it happens, between ICL and EDS. And we had a great mutual respect. I thought he was first of all, he was more of a technician than I. He actually had a degree in mathematics. That's what you got in those days if you were going to be a computer scientist. So he was much more technically oriented than me. And he was also what I describe as better at growing the business than me. I was, if you like, clinical, and the turnaround that I did in ICL during those first years was something that needed a really clinical, objective view of the issues. He was concerned much more with growing the business, and this was one of the reasons why he was employed. We had our offices next door to each other. We'd have coffee together and chat. If there was anything that was concerning him, he would have raised it with me.
You say in your witness statement you had regular weekly meetings with all your direct reports, including Mr. Courtley.
Yes.
And
yes.
did that continue when you were executive chairman?
No, not in the same way. I would have had the weekly meetings I would have had been with Mr. Courtley and with the functional people, but not with the operational people underneath. That was for Mr. Courtley to deal with, including Horizon.
And aside from the matters that you've raised in your witness statement, such as various red and amber alerts, can you recall Mr. Courtley expressing any concerns to you as to the adequacy of the Horizon IT system?
No.
I want to look at the restructure now. It's jumping back, I appreciate. Please, could we bring up FUJ 403693?
Yep.
So this is a set of minutes for ICL Pathway Limited, so
Yes.
the specific company, 15th of August 2000. At this time, you were acting chief executive, I believe.
That's correct. That just about, yes.
And we see you are chairing the meeting. If we go down slightly. Further down, please. Thank you. So I should just say at this point, when looking at minutes, you may see the post office highlighted at various points. You'll see it there. That wasn't on the original minutes. That's something that's added afterwards.
Okay.
So just a point of clarification.
Yes.
So we've got various things of headcount requirements for testing, and then we have the managing director's report. If you go over the page, please. We see there quite a detailed report from the managing director
Yes. Yes.
on various parts.
Yes.
B, CSR, that's Core Systems Release Plus, was a significant
Yes.
issue.
Yes.
Provides detail. C, we have detail on the rollout. And D, weekly service performance, still a key issue. Was this typical of the type of oversight that the board of ICL Pathway Limited would give to the delivery of the Horizon contract?
Yes, I think that's. Yes, I mean obviously it varies with time, but this is the sort of report that we got. Yes.
And in fairness, this is rollout, so it's a busy time for the company.
No more busy than in the development, I think, in a sense, once they got through the acceptance test, which they would have done by then, I think. Rollout is a logistics issue rather than it's much more straightforward in a sense. There's a lot of planning to do, but it's a logistics issue mainly.
Can you recall how often the board of ICL Pathway Limited would meet?
No.
Can we look now at your second witness statement, please? Page 4, paragraph 15. So you discuss here part of the restructure
Yep.
and say in order to make board meetings of all three companies more efficient, and when you say all three companies there, you're referring to the ultimate parent company, Fujitsu Service Holdings, the Fujitsu Services Limited, the sort of intermediate
Yes,
company,
it's those two.
and then the other, I think the third company is the one responsible for non-UK business.
That's correct. It was all three of those.
And the board decided to delegate the oversight of all of the companies to a single management committee known as the Fujitsu Services Management Committee.
That's correct. It was a Fujitsu Limited decision.
When you say Fujitsu Limited, could you just explain the corporate identity of Fujitsu Limited?
Yes, Fujitsu Limited is the ultimate holding company of Fujitsu. It's quoted on the Tokyo and I think the New York stock exchanges. It's an interesting company because it's not only a holding company, but it also runs all of the operations in Japan as well.
Is it incorporated in Japan?
Oh, yes, yes.
So, do I understand your evidence to be that this decision was made by that company in Japan, not a ICL group or UK Fujitsu?
No. I mean, it's a practical matter that they wanted to look at the business as a whole. And there are a lot of Japanese directors and observers coming in all the time. And to have three separate meetings just wasn't efficient. So we dealt with everything at one meeting. And the meetings would go on all day.
So when you discuss efficiency, you're using it in the sense of the word from the holding company above Fujitsu Services Holding, their efficiency, really. They come in and have fewer meetings.
Well, yes, but it didn't impact on the consideration of issues. It was just that we had a very long meeting on one day.
could we just then turn to page 12 of your statement, paragraph 55? Sorry, second statement. For
Yes,
for
the
context, in this, you're talking about quarterly business reviews, and you say for a complete set of meetings comprising this cycle, the quarterly business review cycle, I think, C4 FSMC, so that's the Fujitsu Services Management Committee meetings in 2005. So is that, do we take it from that the plan was for the FSMC to meet 4 times a year or quarterly?
Yes, that's correct. It fit in with Fujitsu's quarterly reporting obligations as a quoted company. And I think I can expand if you wish, but that's the answer to the question.
No, the follow-up question I have is, from the perspective of say, a director on ICL PLC, when this change was made, did it result in fewer board meetings each year?
No.
So before the change, there was 4.
It was following exactly the same schedule from 1990, because from 1990 onwards, Fujitsu Limited had the same reporting requirements as it did in 2000. In fact, when ICL was taken over, it had to change its accounting year to correspond with the Fujitsu accounting year so that the system could work. So this is a long-established tradition.
That document could come down, please. Could we please look at FUJ 403704? So we see these are minutes of the Fujitsu Services Management Committee on the 29th of May 2002.
Yes.
And in your witness statement, you say that this is the first meeting of the FSMC.
Yes, because it took place, we switched the brand, if you remember, on the 1st of April 2002, again to coincide with Fujitsu's financial year. Everything happens at the beginning of the financial year with Fujitsu. And that was the first meeting that we held.
We see that at this point, there isn't, or one of the companies included in this isn't what was ICL Pathway Limited.
No, that's correct, and it wouldn't be, because it was just an operation, just like a lot of other operations. And you've got Mr. Courtley there, who is responsible for all those operations, so it wouldn't be appropriate.
If we look at the, if we can go down, please, so that we see at the bottom we have your CEO report. And talking about the financial year and about the restructuring.
Yes.
If we can go to page 3, please. The CFO report.
Yes.
And just scrolling down, you don't need to read all of this, but you see quite a detailed report which continues until page 8.
Yes.
And we have here Mr. Courtley presenting the new organisational model.
Yes.
How, in terms of the new organisational model, and I'm only really focusing on oversight of Horizon here, what changes were made to the management structure that affected the oversight of the Horizon IT system?
In actual fact, none at this stage. You see the one that says large projects reporting direct to Mr. Courtley.
Yes.
Well, one of those large projects was, at that time, Pathway, I forgot what it'd be called now, ICL Pathway Limited, I suppose. And what happened, just to, if I may, to finish it, in 2003, when we entered into the extension agreement, it was agreed with the Post Office that we would shut down the actual Pathway company, would become dormant, and large projects would then comprise a division within Fujitsu Services Limited, which comprised the Horizon project. And that division became one of the 5 large projects, each of which had a division, if you like, reporting to Mr. Courtley.
The only thing, I think, just to clarify there, when you say the extension, you mean the extension of the date for termination of
Exactly.
the Horizon contract?
Yes, yes,
And it extended to 2010.
precisely.
At this stage, then, so we're in 2002, can you recall what, if any, board meetings were held by ICL Pathway Limited?
No, is the answer. I may have attended some, but without you showing me documents at this minute, I don't recall.
Is it fair to say, from your perspective at this stage, you saw the responsibility as being on Mr. Courtley to present any issues with the Horizon project to the FSMC?
That's exactly correct.
Or that
Well,
that's
or to me.
authorised, or to you in the week.
And then, yes, and then I would have presented it, but that's correct.
That document could come down, thank you. Do you think the restructure had any effect on the level of oversight that ICL Pathway, then Fujitsu Services Holdings Limited, had on the Horizon IT system?
I think it would have had a beneficial effect, because what you have now is Mr. Courtley, who has great experience in IT. He's much more technically oriented than me, and I believe it would have been, let's say, a more piercing oversight is the word I'd use, yes.
Before I move on to look at a couple of specific topics, just for the purposes of the timeline, I want to complete your career history. In April 2007, you became Corporate Senior Vice President and Head of Fujitsu EMEA Regional Operations for Fujitsu Limited.
Yes.
So that's the company, overall parent company incorporated in Japan.
Yes.
Did you remain a director or involved in Fujitsu Services Limited or Fujitsu Services Holdings PLC?
I would still, from my recollection, be chairing the FSMC. That's the limit of it. So from that stage onward, anything that I really knew about operations within that group of companies would have come via the FSMC meetings.
And at that stage, would you have had, I'll rephrase that question. Did Mr. Courtley report to you directly or indirectly once you became Corporate Senior Vice President?
I'm trying to think, I'm thinking very carefully about the answer so I can give it to you. it would have been directly, in a sense. There was still a line, but that line would have been fairly tenuous. I mean, at that stage, he was acting like any managing director or chief executive of a subsidiary, reporting to what I described as a holding company. So there was a line, but he was running the business as he saw fit. I had confidence in him, and that was it. Yeah. I was ultimately responsible, I think is the way I will put it, for the way in which he managed the whole of the business. But that's like a normal chairman of a board, in my view.
What reporting line, if any, did you have to Mr. Duncan Tate?
Duncan Tate was, I've got to think about this. I think, and I'm saying I think, that he came on board, came from Unisys as a director courtesy title of, I think, the commercial business unit in those days, which I think had Pathway in it. He would have reported to David Courtley. So it's a very indirect line as far as I'm concerned. And by the time, don't forget, by the time he came on board, I was practically based in Tokyo. I mean, I went to live in Tokyo in 2010. So, yes, I knew him. I had a lot of respect for his competence. Mr. Courtley left in 2009, I think. There was a short interim period when I just sort of held the reins. I don't know, I wouldn't say I was overseeing anything in particular. I appointed Roger Gilbert for a short time as chief executive of what was then Fujitsu Services Limited. We'd broken, I've got to go back to this, but we broke up the original group once we were reorganizing as a global business group. And what was there was Fujitsu Services Limited. ICL PLC was, it was a legal entity, but it was not really managing in any sense of the word. So Duncan Tate was in charge of commercial unit. Pathway was in it. There came a time in 2010 when we wanted to make a more permanent chief executive for Fujitsu Services Limited. There were two people who were candidates, and about my last executive decision, if you like, was with the consent of Fujitsu Limited, my colleagues on the board, as it would have been in these cases, I appointed Duncan Tate as chief executive of Fujitsu Services Limited. That's 2011. At that stage, I retired, in effect, because, frankly, at 67, this was becoming a bit too much for me. And I spent a year. Fujitsu Limited tends to give its directors a kind of sabbatical before they retire, is the way it works. And I took my sabbatical in Singapore. I was a kind of corporate executive advisor, but I didn't really do anything very much. And then I left, returned to England, and that was the end of it. I can stop.
Before I
Yes.
move on, do you recall at any point Mr. Tate advising you of any concerns he has about the Horizon IT system?
The only connection that I have with him in this issue is the document which you showed me. I can't remember the name of it, an exchange of emails in which he wanted to set up.
Well, if that's your only recollection... That's
the only... I can't remember whether it happened or not, to be honest.
We'll come to that
yes,
shortly.
Yes, but that's all, nothing else.
Right, I'm going to move to a different topic now. Could we please bring up your first witness statement, page 22, paragraph 67. So you write at paragraph 67 that I've been asked whether or not Horizon could be considered a robust system. In all my experience of over 40 years working in the telecommunications and IT industry, I have never come across the use of the word robust as a contractual term. With respect, I think it is a subjective term without any precise legal meaning. I believe that the only pertinent questions in relation to the Horizon system are A, did the system pass the acceptance tests? And B, was it delivered in accordance with the contract? Both of these conditions were satisfied at the end of rollout in 2002. So, effectively, as I understand it, you're saying from your perspective, the key questions are, one, the product produced by Fujitsu and delivered to the post office, did it pass the contractual acceptance tests?
Yes.
And secondly, in respect of the ongoing obligations, was Fujitsu delivering those in accordance with the contractual standards that had been agreed between the parties?
Yes.
Could we please look at page 26, paragraph 79? You say, my objectives in negotiating the codified agreement. Now, posing there, the codified agreement was the agreement entered into between Post Office, then Post Office Counters Limited, and ICL Pathway Limited in 1999.
Yes.
So the objectives in negotiating that were to create a detailed specification and precise acceptance criteria. When you say detailed specification, is that referring to a specification of the services that ICL Pathway were to provide to Post Office?
That specification that I was focusing on was the specification of the system,
Okay, so
because that's what's passing the acceptance tests.
it's when we sing a detailed specification, is that referring to a set of contractual clauses that set out the specification for the system that ICL were supposed to deliver to Post Office under the contract?
Yes, it was in a schedule to the codified agreement.
You say you focused on the main provisions of the codified agreement in order to achieve the above objectives. I had little involvement in the preparation of the schedules and appendices of the codified agreement, which I never read.
Yes.
I want to look at the codified agreement now.
Okay.
It's FUJ 6071. Now, this is a document of over 900 pages, so it may be that we need to catch up a little bit with the computer system. But
Okay.
this is the codified agreement. Could we turn to page 12, please?
And sorry, what's the reference for that again? 7-1 at the end. Thank you.
7-1 at the end, 6 zeros. I'll start that again. FUJ, 6 zeros, then 7-1.
Yeah, thanks.
If we could go to clause 102, spot 1, please, which is... So that's a interpretation clause, which is standard in these contracts.
Yes, yes.
And said, as used in this codified agreement, the terms and expressions set out in Schedule A1 shall have the meanings ascribed to them.
Yes.
And as is standard, for example, we see at 103 spot 3, we see...
Which one?
Sorry, if we go up, I misspoke, sorry. 101 spot 3.
110, sorry. Yes.
Yes, we see defined terms as is standard are capitalised, so things like contractor.
I'm sorry, I'm lost here. Just tell me again.
I'm so sorry. It's 103 spot 3.
I'm not seeing that on the screen.
All right. I'm 101 spot 3. I've done the same mistake again. Thank you, Mr. Blake.
So you want me to look at 101 spot
101
3?
spot 3, yeah.
Okay.
Can you see that now?
Yes, now I can, yes.
It would help if I said the right clause. That would be of assistance. We have, for example, it says the contractor capitalised, and throughout this agreement, defined terms tend to be capitalised as a
Yes.
standard.
Yes.
So, in order to understand this agreement, you would presumably accept that you would need to be familiar with Schedule 1A1.
This is the interpretations.
Yes.
Yes.
And so,
In that sense, I did read it, yeah.
I was going to say, putting yourself back, you probably, whilst you may not have
I-
been affair with everything in the schedules, you will have had some.
Oh, that's fine, but I'm talking about the whole
Yes, of course.
900 pages.
Could we go, please, to page 17? And if we could go down to the bottom there, thank you. We have part 2, performance of Post Office Counters Limited services and supply of products. And clause 201 spot 2 says this, subject to clause 201 spot 6, the contractor shall be responsible for meeting the requirements specified in Schedule A15 in accordance with the solutions specified in Schedule A16 by performing the core system services referred to in clause 201.3. So breaking that down, what we have here is firstly, there was a Schedule A15 which set out Post Office's requirements for the contract.
Well, those particular specifications with the solutions specified, yes.
Yes. And there were solutions specified, as you say, in Schedule A16.
Yes.
Now, when you were involved in the negotiation and the tender, would you have been involved in considering the requirements and solutions for the products?
No.
The clause here then says that in order to meet the requirements, ICL Pathway had to perform the core system services referred to in clause 201 spot 3. So if we could look at 201 spot 3, please, which is on the next page. Thank you. We have subject to clause 201 spot 6. The contractor shall perform the following core system services in accordance with all applicable provisions hereof. So this is essentially setting out what ICL is supposed to do under the contract,
Yes.
or part of it, I should say.
Part of it, yes.
So this is a very important clause in the contract. Would you agree?
Yes, yeah.
Would you agree that it's fundamental to the specification of the product and services to be provided?
Well, it describes what they are, and then you have to look at the definition. So I suppose so.
We'll look at two of them. Paragraph 201 spot 3 spot 1 says that ICL were to provide the development services pursuant to clause 403.
Yes.
And 201 spot 3 spot 3, also the operational services pursuant to clause 405. Can we look please at page 26? And go to clause 4 403. So these were the development, is the clause that defines the development services.
Yes, 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 and it has loads of schedules attached to it, so far as I can see, which would give you the specification of the development.
Yes. So,
Yes.
and at 403 spot 2, it says development of EPOS. That refers to the electronic point of sale
Yes.
system,
Yes,
as described in Schedule F1.
yes.
And then if we can go over the page, I think, to clause 405. We have the performance of the operational services. And it says, subject to the Release Authorisation Board authorising commencement of national rollout of the core system, and subject to clause 201 spot 6, the contractor shall, from the date of core system release acceptance, perform the following operational services. Now, these obligations effectively kick in after acceptance.
Yes, after acceptance, and the way I think of these as service provision, and service provision obviously can't start till you've got something rolled out that you can provide the service for. So it develops progressively as rollout takes place. Yes, yeah.
So you say that you were involved in drafting precise acceptance criteria for...
Well, when I say I was involved, what I was involved in was ensuring that the technical people actually did it. Because one of the biggest failings in IT contracts is when they come down to it, they end up without a specification and without acceptance criteria. I was taught this from 1975.
And as part of that, you would have presumably needed to review the contract and see what services or what specification was being agreed.
No, it's not something that I would have looked at, because this was dealt with by people who were responsible for providing it, and they will produce the necessary services. I wouldn't want to go beyond what's in clause 405, and even that needed input from, if you like, technical people who knew what to write in clause 405. What I was concerned with was that it happened, not with its content, and I wouldn't pretend to be competent to criticise that content.
So is your evidence that in terms of internal lawyers within ICL at this point, was it, well, no, I won't say is your evidence, I'll ask you. In terms of internal lawyers within ICL at this point, were there any lawyers that you're aware of who were monitoring or reading what was in the schedules?
This would have been done by masons. I'm sorry if we are, they're now Pinson Masons, I think. These were long-time solicitors. First of all, for STC, actually, I knew them. And there was a person called Ian Monaghan, who was the head of a team of lawyers who was looking at all of this and working with the technical people. It wasn't done by lawyers within ICL as it was in those days, I suppose, but it was done by a properly qualified legal team, and masons were expert in dealing with IT matters. I used them on many occasions.
But presumably someone within ICL would want to know precisely the nature of the obligations that ICL was signing up to.
Of course they will, but they will be the technical people who will then consult on the drafting with masons.
So your evidence is in terms of the lawyers wouldn't have read the Schedule F1.
No, I'm not saying the lawyers wouldn't. Masons would have done. People in masons, they had a whole team. And they would have worked with the technical people in ICL. I was there with Stuart Sweetman to oversee that things happened and to look at any real points of conflict in the main agreement. And I don't think there were very many, actually.
Well, let's look at Schedule F01. It's page 587. So this is the EPOS service definition to which those clauses we just looked at referred.
Yes.
And it says this schedule details all the requirements relating to the EPOS service
Yes.
which the contractor shall provide.
Yes.
And so your evidence is, as I understand it, that did you not consider this to be a document that someone internal to ICL would need to, or a lawyer internal to ICL would need to read to understand the specification of the product that was being provided?
The point is that there had to be competent legal advice surrounding it. This was done by Masons, and it was done in accordance with what the technical people were negotiating on both sides, Post Office and ICL. So what would happen is there would be a lot of technical discussions. They would be writing it, and Masons would look at this and turn it into, if necessary, rather more legal wording. But at the end of the day, the substance which is provided in these schedules has to come from the technical people on both sides. This is how they worked it out. And there's nothing that I could personally add to that.
If you look down, we see scope, and then it sets out the 4 service boundaries. And further down, please, it says constraints. And we've got various paragraphs there. And we see in the brackets R808 referring to the requirements which we went to earlier.
Yeah?
Could we go, I think it's 2 pages, I think there may be a blank page on the next page. Thank you. And just further down, please. And 3.8 says, EPOS shall be a robust
Oh, well, there you are.
POCL
Yeah.
service, including features too, and then it goes on to set that out.
Yeah.
It-
Well, it's quite clear that I never saw that, and I can't comment further.
Is your evidence that the, well, let me ask it another way. What was your understanding of the adequacy of the EPOS, or let me rephrase, sorry. What was your understanding of what Fujitsu were required to provide to Post Office in terms of the adequacy of the EPOS product?
I don't think I had any particular understanding. I know what an EPOS product is, point of sale, basically. I'd assumed that there would be a specification for it and that it would be supplied to that specification.
And I take it from your evidence that these types of matters of whether the product was robust didn't arise in your management discussions with your reports?
No.
So that's probably a good time to take the morning break.
Very well. What time should we resume?
If we could say 11:10, please.
All right, thanks.
Thank you.
Thank you.
Good morning, sir. Can you still see and hear me?
Yes, thank you.
Thank you. I'll carry on. I want to now look at some specific examples of the management of the contract. Please, could we look at FUJ 30808690? This is a document the inquiry has seen before, particularly in phase 2. Title is Report on the EPOS Pinnacle Task Force. The date in the top, 14th May 2001, but we can see from the abstract that it is referring to a task that happened between 19th of August and 18th of September 1998.
Yes.
Firstly, the distribution list, T. Austin, M. Bennett, M. McDonnell. What do you recognise those names?
Yes, both of them reported, well, certainly Martin Bennett reported to the Managing Director of Pathway, and he was responsible for, I think, quality and customer services from recollection. Terry Austin, I'm not quite sure whether he reported directly to the Managing Director or not. I don't really recall McDonnell.
So did you ever have any direct interactions with Mr. Austin or Mr. Bennett?
No, not that I can recall.
If we turn the page, please. Just for assistance with dating the document, we can see version 0.1, 18th September 98, and then on the 14th of May 2001, raised to version 1, administrative catch-up. Could we go, please, to page 4? Just going to go through a few bits of this document. I should ask first, sorry, before you were sent this document by the inquiry, had you seen it before?
No.
So in the introduction, it says, during the week commencing 17th August, the EPOS/Counter Pinnacle Stack Reduction Team, known as the Task Force, was established. The objectives, current workload, composition, outline process and targets were presented to the team on Tuesday 18th with a formal start date of Wednesday 19th of August. It goes on to describe presenting the outcome of the activity and identifies factors which prevented the original target, zero or near to zero residual pinnacles, being met. During the course of the task force, it became clear that there are significant deficiencies in the EPOS product, its code and design, and these are also presented in this report. Can we look then at page 7? There's a section on the EPOS code. It says it is clear that senior members of the task force are extremely concerned about the quality of code in the EPOS product. Don't need to read it all, but we see the last paragraph in that section. It says lack of code reviews in the development and fix process has resulted in poor workmanship and bad code. And then if we could turn to page 17, please. At the bottom, section 7.3, we see example 1, and it gives an extract of some code that's designed to reverse the sign of a number and is equivalent to the command. Fortunately, we don't need to concern ourselves with the code itself, but over the page, it says whoever wrote this code clearly has no understanding of elementary mathematics or the most basic rules of programming. So you say you hadn't read the document before.
I've never seen it.
Never seen it. Were you made aware of the issues that this document describes?
No.
Do you accept that these are serious issues being described by the document?
I'm not technically competent to say. I mean, for instance, you say it's bad code. I've got no idea if it's bad or good.
Well, if you don't have technical competence, you presumably need to rely on technical people.
Well, I would also point out to you that there's a second document which mentioned the CSR Plus, which you also sent to me as the additional documents. And I looked at that, and I can only give you my impressions because I've not seen either of these documents, but I'm happy to do so. The first is that was in 1998, before the codified agreement. So water had flowed under the bridge for almost a year in terms of the development. And the second point is, if you look at the action points in the CSR Plus document, it talks about this. And
We
what
are
it's-
going to come to that
You'll
shortly.
come to that. Okay, that's fine. So I'm just saying that you have to look at both of them in context.
I want to look at this one in context at the time that it was drafted, as you say, in 98.
Yes.
Do you accept from, you've read this document, I've taken you to extracts from it, do you accept that it's describing a serious issue in the EPOS code?
It's describing an issue which has got to be corrected, and that's what they're talking about. How serious it is, I couldn't tell you.
Why do you think that the issue being described in this document was not raised with you at the time?
It's a technical issue, and it's not something that would have been raised at board level. That's what I think. I think this was too detailed for the board.
Well, this is going really, isn't it, to the heart of the product that's being produced by ICL.
I
Accept
can
that?
hypothesise many reasons, but I'm telling you that it wasn't, and I can also say the reason that it wasn't, so far as I understand these things, and I think Mr. Muckow, I think he's called, said much the same thing in his evidence, not at that level of granularity, and I'd agree with it.
So your evidence is that this type of issue is something that should be just dealt with at management level and it shouldn't concern the board?
It's a technical issue which should be dealt with at a technical level. And when we come on to the CSR Plus document, which you're coming on to, I think that's clear to me.
Well, let's look at that now.
Yeah.
I think we talk about the same document. It's WITN 046000104, please. So we have here schedule of corrective actions, CSR plus core system release plus development audit. Is this the document
Yes.
you're referring to?
Yes. And you can see that it's gone up to the Managing Director Stairs and Mike Coombs, who are the two, and they're all down here, Bennett and Joanne Austin. Yep.
Did you see this document at the time? I think you said earlier you didn't.
No, I didn't.
Could we please turn to page 4? The introduction says this document presents the corrective action plan that emerged from a post-audit meeting following the audit of the operation of the CSR Plus development. And at page 6, we see the start of various report observations, and then on the penultimate column, action points, which I think
Yes.
we were referring to earlier.
Yes.
Could we turn, please, to page 9? So we see in the report observation / recommendation, it says the audit identified that EPOS continues to be unstable. Pinnacle evidence illustrated the numbers of pinnacles raised since the 1998 task force and the rate of their being raised. The EPOS Solutions report made specific recommendations to consider the redesign and rewrite of EPOS, in part or in whole, to address the then known shortcomings. In light of the continued evidence of poor product quality, these recommendations should be reconsidered. Now, before we look at the action points, can I ask whether you recall any discussion that you were involved with where management of ICL were considering or raising rewriting the EPOS application?
No.
If we look in the the agreed action points, 25th of the 11th.
20, hold on, yes.
It says work on AI, sorry, if we could... It's
The one above, isn't
please.
it?
Yeah.
Yes.
Work on AI 298. That's referring to an acceptance incident, isn't it?
Yes, and it's something to, well, I understood this because I've read the various documents. So far as I can see, it's something to do with print error and printer handling, whatever that is, yep.
So, well, it said 80% of problems, this is saying, were to do with error and printer error handling.
Yes.
Daily meetings instigated. TPA, does that refer to Mr. Austin?
The answer is it might do. I don't know if he had a P in his name.
TPA is of the view that while original code has not been good, it would be difficult to justify the case for rewriting now. There's then what appears to be copied from an email from TPA. We've not formally closed down the recommendation that we re-engineer the EPOS application due to its inherent instability. It goes on in the final paragraph on this page. We will, of course, continue to monitor the Pinnacle stack for the next few months and, if necessary, re-evaluate this decision.
And they say would close this issue formally, whoever Jan is. Would Jan please close this issue formally?
And then if we turn the page, please. So we're now, that was in 25th of November 99.
Yeah.
We're now into December and then into 2000. On the 10th of May, it says, following response received from MJBC. Is that Mike Coombs?
Yes, it is Mike Coombs.
As discussed, this should be closed. Effectively, as a management team, we have accepted the ongoing cost of maintenance rather than the cost of a rewrite. Rewrites of this product will only be considered if we need to reopen the code to introduce significant changes in functionality. We will continue to monitor the code quality based on product defects as we progress the final passes of testing, and it continues to closing the ticket.
Right. Yes?
Now, there, when it says the management team, to who's being referred to there?
Mike Coombs would have been referring to all the people that you saw on that CSR Plus list, I presume. Think of the management team within Pathway.
Would you accept that what's being discussed here is a significant decision as to whether or not to incur the costs of rewriting the EPOS application or accept the costs of maintaining it in the state it's in?
I mean, I've seen this before, but in some of the witness statements or the questions, but I don't think this is the issue. When you look at this, yes, there is a cost to maintaining it, and if you like, there's a penalty in that. But I've seen this many times with software engineers. It's a bit like lawyers, when they review cases, everybody's got their own opinion. Software engineers always say, some of them do, oh, I could rewrite this and it's better. Well, maybe they can and maybe they can't, but under the circumstances of this contract, what the management team decided, and it's a technical decision, and they're accepting, in my view, a cost penalty to do this, because it's safer to keep with the EPOS, which is the thing that you know, monitor it, and they say it's been improved since 1998. We've moved on 2 years now nearly. Rather, it's a complete step into the unknown to start rewriting. And if you rewrite a program from scratch, you've got no idea, is it going to work better? Is it going to work worse? Will it fit in with everything else? From my opinion, it's a technical decision. Let's suppose that they'd showed this to me, or they'd showed it to the board. What would have been said was, well, this is a technical decision, what do you advise? And that's what they advised. Nobody saw this outside of them, but that's outside of Pathway, but I don't think it makes any difference.
Well, let's stand back. The ICL have contracted with Post Office to provide a system on certain terms.
Yeah.
And we saw earlier, one of those terms was that it's robust.
Yes, we don't know, and I insist on this, we don't know, there's not a legal definition of robust that I'm aware of. Maybe you have one, I don't know, but to me it means, comes I think from Latin, robust, strong, or something like that.
Well,
Able
if
to
we
withstand shocks.
if we can, well, no, we'll pause it. We'll come back to that point. The point is the parties agreed that a robust system would be delivered. Is that fair?
It's in the contract.
It's not for the technical people to determine whether or not that ICL are acting in compliance with their legal obligations to Post Office, is it?
I think that's true, but it's the technical people who would, in the end, have to produce some opinion, as I think Adrian Montague did at one stage and said the system was robust, whatever that means. But the technical people would have to tell you. I can tell you what definitions of robust, I can look it up in the dictionary.
Well,
but whether it applies to the system...
The technical people can provide you advice on the application itself.
Right, and they advised that it was better to go ahead with the... not to go ahead with the rewrite, but to go ahead with that. I can't question that decision, and I didn't know about it.
But would you not accept that the board, in order to understand whether or not its legal obligations are being complied with, should be advised of a serious concerns in the product that's being delivered?
Not if the incident was closed.
So in your view, is it your evidence that once the technical people have decided that this doesn't need to go to the board, that's it, the end of it?
That's exactly what I think.
In your view, what role then does the board have in overseeing the quality of the product that is being produced or delivered to the Post Office in this circumstance?
Right, I'm sorry, not the Post Office. The board has to have overall responsibility for seeing that there are properly qualified people who are doing defined jobs in connection with the implementation of the project. That's what I believe is the job. Their second job is to trust those people and, when appropriate, through the mechanisms that I talk about in the second witness statement, to review progress on the project, like all other projects. And the board is dependent upon the reporting channels which provide information to them, which ultimately, via the QBRs and all these other things we've described, turns up as a financial officer's report and a chief executive's report, which the board considers. I've also not talked about, and I imagine you'll come to that, the particular Japanese oversight of this, but that's a different matter. It's in my witness statement.
So do I take it from your evidence that you're not critical, or no, let me put it another way, are you critical of the management team for not raising this with the board?
No.
What steps did you take, or the board take, after appointing the management team to monitor Pathway to ensure that they were doing a proper job?
I've told you the reporting structures that I've described.
Well, if you pause there, if the reporting structures rely on the management team to flag problems to you, how did the board satisfy itself that problems were appropriately being flagged?
Because they would question the chief executive. The chief executive would, in the initial case, talk to the COO, and later on it would have been just the chief executive. He would have had quarterly business reviews with Pathway. That's not board meetings, this is management meetings. And those management meetings would have surfaced to him anything that he thought appropriate to report in his chief executive's report to the board. And I have to say that when you talk about the board, you must remember that the board is a majority of Japanese directors. And I've talked, I don't know whether you want to come on to this, about the flows of information which actually existed outside of the board meeting reports to the Japanese directors in Japan. And I can assure you these were very detailed, dealt with by people who were on the ground within Pathway. I told you that we had a large team of software engineers from Japan within the development at that time that you're talking about.
So that's a flow of information from directly to Fujitsu Limited.
The way it works, so, and it's, if I may, I'd like to expand on this because it is actually, in my view, really critical. The way Fujitsu worked was they had software engineers embedded in the development, and there were a large team of them. I can't remember the number. There was actually a legal advisor from Japan. He was a chap called Yasui, whom I know very well. The interesting chap. He was qualified in the New York bar and as an English solicitor. So you also had people who were, well, there's the chief finance officer, Adachi. He reported direct to the chief finance officer in Japan. All of this stuff is a huge amount of information, which is what Japanese like. And it all went through this overseas office, which is about 40 people in Tokyo. And their job is to sit and collate all this information and brief each Fujitsu director before that person gets to the board meeting. And I know this because when I was in Tokyo, I was recipient of the same thing. And I'll just tell you this and then I'll stop. I'm sorry, but I've talked too long. They give you what's called a temochi. Te means hand, mochi means hold. And what it can mean two things. Something you hold in your hand, a handbook, or something that holds your hand and looks after you. And what you get is an A5 book about an inch thick. It's literally like this. And inside it, what you get is the answer to all the possible questions that you could raise or might raise when you go to a board meeting. Now, I'm not saying the English directors had this, but I'm saying that the Japanese directors, who were a majority on the board, who controlled the board, had it. And I can't believe that between all of this, if there were serious issues that the Japanese were concerned with, they would not have raised it through that chain as opposed to the standard reporting chain that went up to the board inside Fujitsu. That's all I can say, but I know how detailed it is because I've lived in Tokyo and I've been a recipient of it.
So that's looking at a reporting line from what was happening in ICL Pathway through to Fujitsu Limited Incorporated in Japan.
Precisely. I mean, it was outside. It's outside the normal system. Nothing wrong with it. I'm not saying it shouldn't have happened. I'm just saying it's at least as important.
I want to ask about, we've discussed the board of ICL Pathway / ICL PLC. In terms of what sat below that, so the management committee, which we discussed previously, Are you critical of the management team that we referred to earlier in relation to the CSR Plus release? Are you critical of them for not raising this at the management committee?
You mean an FSMC, a Fujitsu Services Management Committee?
No, in the start of your evidence, we discussed the board and how often that met. And then I understood what you said was there was a weekly management committee meeting within ICL.
When it was, and this is before my time, this weekly, let me be specific. In the times of ICL, there was an ICL management committee. We talked about that, and I said that at that time, the Pathway MD or whatever did not attend that management committee. When we're talking about my tenure, there was a weekly management meeting. The Pathway would not have attended that meeting. It would have been other people. And particularly once Courtley was there, no operational people would have attended. Where I could criticise, and this is hypothetical because I don't know, is whether this was ever surfaced during the preparations for the quarterly business reviews, and that I can't tell you. But certainly the quarterly business reviews that fed into the board didn't contain that. I say maybe they should, maybe they shouldn't, but I don't know.
Let's break this down.
Yeah.
Before 2000, so before your chief executive, at ICL PLC level, are there weekly management meetings?
No, they were operational meetings at the group level. Yes, I suppose you'd call it that. Nobody really thought about ICL PLC. They just thought about ICL.
So at the group level?
At the group level, yes.
And just to be clear on the timeline, at that point, was the managing director of Pathway attending the group level management meetings?
No.
How,
not so far as I can recall, that's all I can say.
From your recollection, and so we're clear on this, how were issues with regarding Pathway raised at the ICL group level?
They were raised by the chief executive, Keith Todd in that case, reporting to the board.
So it would the reporting line would be managing director of ICL Pathway,
yes,
reports to Keith Todd,
yes,
and then it's Keith Todd's responsibility to consider whether to pass that on to the management committee.
That's correct, yes.
At that
Excuse me, rather than deal with this in the abstract, can we just go back to this particular issue relating to EPOS, to which the inquiry has devoted a significant amount of time? Is it your view, Mr. Christou, that the issues relating to EPOS were appropriately, in inverted commas, managed by the team that took the decision? Or is it your evidence that the team that took the decision should have reported it upwards to someone?
No, my evidence and my belief is that they took the appropriate action, and that was the end of it.
Right. You would not have expected them to have gone any higher than they did, in effect.
No, I wouldn't.
Right. Okay. I understand. Because it seems to me, with respect to you both, that whether or not something goes higher must relate to the specific topic under consideration rather than a general discussion, if I can put it in that way.
Yes, sir.
Yes.
Thank you. Let's look at another specific example then. It's FUJ 3088036. It's another document the inquiry has seen.
I produced this in my second witness statement, I think.
I think this was more recently provided to you.
Yes, I haven't seen it before. I actually asked Morrison and Forster to give me some more information on this, and that's where I saw it. Didn't see it. I haven't seen it before.
Didn't see it at the time.
No.
So it's the 2nd of August 2002 is the date.
Yes.
At this point, your chief executive.
Yes.
If we look at the originated department and the contributors, do you recall working with any of those people?
They frankly, let's have a look. No, none of the. I don't recall knowing any of those people.
This document describes, well, in fact, let's look at page 9, please. It says SFS, which I
don't know who they are.
the Security Functional Specification.
Okay.
And it describes a form of remote administration, a tool called Tivoli Remote Console.
Yep.
It goes on to say that this has led over time to BOC, Belfast Operations Centre, personnel relying heavily on the use of unauthorised tools, predominantly our client, to remotely administer the live estate. Its use is fundamental for the checking of errors. The tool does not, however, record individual user access to systems, but simply record events on the remote box that the administrator access has been used. No other information is provided, including success/fail, so it is not possible to simply audit failures. The use of such technique puts Pathway in contravention of contractual undertakings to the Post Office. Were you made aware of that, the concerns raised in that, in particular that Pathway was in contravention of contractual undertakings to the Post Office?
No, I've never seen this document.
Is this a type of document, or maybe not, let me rephrase that, the issue that's being described, in particular, the use of such technique puts Pathway in contravention of contractual undertakings to the Post Office. Is that a type of issue that you would have been expected to be raised to you as Chief Executive?
It depends whether the Post Office have made any. If the Post Office have made a formal complaint, a breach of contract notice, for instance, then I would have known about it. I read this in conjunction with another document which you showed me, which you may come to later, which is Gareth Jenkins writing earlier about the secure shell, whatever it is, the SSH, which is designed to, as he says here, provides an acceptable and agreed level, which I presume must be agreed with the Post Office, of secure access. So reading this, what I see is, well, there was a problem. Maybe it was a breach of contract. Maybe it wasn't. I don't know. The Post Office appear to have known about it because it says acceptable and agreed, so it must be agreed with somebody or other. And it was remedied with this secure shell. Whether it's a correct remedy, again, I'm not competent to say, but that's what it looks like to me.
Well, let's look in more detail at the problem. It's page 15, please. And it describes third line and operational support.
Yes.
It describes controls, so individuals involved in the support process undergo more frequent security vetting checks.
Yeah.
Other than the above, controls are vested in manual procedures requiring managerial sign-off, controlling access to post office counters where update of data is required. Otherwise, third line support has unrestricted and unaudited privileged access, brackets, system admin, close brackets, to all systems, including post office counter PCs. And the risks are highlighted further down. Oh, sorry, if you stay there, please. Sorry. It says this exposes Fujitsu Services pathway to the following potential risks: opportunity for financial fraud, operational risk, errors as a result of manual actions causing loss of service to outlets, and infringements of the Data Protection Act. I mean, this is, would you accept this is a very significant problem going to the heart of ICL's contractual obligations?
No, I think all he's saying is we need to beef up our security systems, and we're doing it. That's the way I read this. But as I say, I've never seen the document, but this is how I read it. Yes, there is a risk. I'm sure you understand that third-line support are a few specialists who are very carefully vetted, who are system administrators, but there has to be somebody who can be a system administrator, and there aren't very many of them.
Would you accept that what this is saying is that some people have unaudited privileged access with system administration access to all systems?
What I'd accept is...
Post office counters.
I'm sorry, I beg your pardon. What I would accept is that at that time there was an issue and they improved the security systems on the advice of Gareth Jenkins on his previous document. And don't forget, we've only just at this stage got to complete rollout.
So here, where we have an issue that's being raised, that is said by the technicians to be, or it's warning of a breach of contractual obligations, your evidence is this didn't, you're not critical of it not being raised with you?
If there were no solution to it, or if there had been a formal complaint by the post office, I would then have been critical, because if there had been a formal complaint, then that was something that definitely should be looked at. What I'm seeing here is a technical person who is identifying improvements in security which will prevent some issues. And every contract for the development of software is always trying to improve its security. We know nowadays that the most important thing for fixes, if you've got your PC or your smartphone, every so often you get a security update to protect it from outside interference. And this is a more technical and more sophisticated way of doing things for this system. I'm not critical of them. I would be critical if the post office had sent a letter. That's a different matter. And maybe that should have been surfaced, but I haven't seen a letter.
Why is it relevant, or why should it come to you if the post office raise it?
If the post office raised a formal breach of contract, then that would become a matter that certainly we'd be looking at, because the first thing I would be doing would be going and talking to Stuart Sweetman to find out what it was about. As
part of the responsibility of the chief executive in respect of the lawfulness of the company's operations, do you not accept that actually where such a serious contractual issue is raised, that should come to you at the highest level?
No, I don't, because I think the problem has been solved at a technical level.
Could we move on to Horizon Online, please? It's FUJ 30095628. And this is an email to which you referred earlier.
Oh, yes, I know about this.
If you could go to the second page, please.
Yep.
So it's an email from Duncan Tate. You're not in copy. I assume you wouldn't have seen this at the time.
No, not at all. This is an issue for Duncan Tate, not for me.
It refers to meetings between Post Office and Fujitsu. And it talks about their confidence has been knocked due to, firstly, ongoing issues with Oracle stability impacting HNGX stability. 2, data center outage. and 3, an outage caused by Fujitsu operator error last week, which caused a 45-minute loss of service. We then get some requests from Post Office. One is to look at P&L for the account to make sure it's sustainable and asking for an open book arrangement. 2 is for an independent review. And then 3, finally, he wants Dave Smith to have some dialogue with Richard C. I assume that refers to you.
Yes, it does, yes.
So they can test the Japanese board's commitment to the account and programme. Firstly, can you recall whether you were aware of the issues described in this email?
No, the answer is I wasn't, and I'd never seen the email. I mean, it would be for Duncan to talk to you about that.
Do I take it that then you can't recall Duncan passing on or discussing these issues with you?
No. Well, let me be clear about this. The only one I think he would have passed on to me was the dialogue with Dave Smith about the Japanese board. Remember, at this time I was living in Tokyo and I was responsible for the global business group as a whole. I don't remember whether we ever had that call. That's all I can tell you. But if I had have done, I mean, what its purpose was to talk about the Japanese board's commitment. It wasn't about things like an Oracle outage or whatever it was. That's all I can say.
I want to look at another document now, please. It's POL 30-28838.
Yes.
It's a document well known to this inquiry. Firstly, can I ask when you first saw this document?
When you sent it to me, which would have been sometime in May.
Do you... So, looking at the attendance list,
All right, let's have a look.
this is in... It's not dated, but the inquiry understands in October 2010. Were any of those people in the attendance list reporting directly or indirectly to you
No.
at that stage?
Could I ask one question about this, please? When I read it, I wasn't clear who originated the document. It looked to me like the Post Office did, but they talk about we and so on. Can you tell me that? Or?
Well, I'm going to ask you. I'll ask you questions about if you saw it or if you didn't.
Oh, all right, okay. But I never saw it, and the only name I know, because of all the fuss about it, is Gareth Jenkins. No, but none of these reported to me.
Did you know Gareth Jenkins when you were working at Fujitsu?
Not that I can recollect. It wouldn't be somebody that I would have had direct contact with.
Now, this document describes what we now know as the receipts and payments mismatch bug.
Yes.
Were you ever given any information on the bug described in this document that you've now read?
No.
That document come down, thank you. Just before this, that was 2010, in May 2009, Computer Weekly ran an article on the Post Office prosecuting sub-postmasters and allegations as to the adequacy of the Horizon data to support those prosecutions were raised. Were you aware of that Computer Weekly article at the time?
No, I wasn't.
I want to look now then at prosecutions, please. Can we bring up your second witness statement, page 21? And it's paragraph 101.
Yeah.
You say, as already stated in my first witness statement, I had no knowledge of this issue, and I do not recall it being raised at any board meeting when I was present. see paragraph 75 onwards.
Yes.
If we just scroll down slightly, please. Thank you.
Yeah.
You say, I would now, however, like to comment more specifically on this point in the light of further documents not known to me at the relevant time, which have since been provided to me by Morrison Forster at my request
Yes.
for the purpose of completing this statement. So everything that follows, when you, for example, you say, my understanding is that the requirement in the codified agreement, that's your understanding today,
Now. Yes, that's correct.
not at the time.
Not at the time.
Could we please go to FUJ 6071 again? And could we turn to page 196, please? So we referred to this earlier, that's Schedule A15 setting out requirements. And we see a number there of various requirements.
Yes, yes.
If we turn, please, to... Apologies. If we can go, please, to 291. Page 291, please. Thank you. Schedule A16 is the solutions. So these are the response, in effect, from ICL pathway. Could we look, please, at page 363? If we could go down slightly, please. I think I may have an incorrect reference here, sorry. We can go up, please, to reference 393, I think. Just bear with me, I will just find that reference. Uh, 393, please. Page 393. That's it. If we could go up, I got my requirements and page numbers mixed up. So
Oh, here we are, yes, page.
if we could go up, please, slightly, so we can see the start of the reference.
Yeah.
So there, reference 829. And this refers to pathway, it says pathway confirms that will ensure that all relevant information produced at the request of POCL, Post Office Counties Limited, shall be evidentially admissible and capable of certification in accordance with the Police and Criminal Evidence Act 1984 and the Police and Criminal Evidence Northern Ireland Order 1889. And it goes on to say about data volumes. When you were involved in the tendering process, would you have been involved in this, in dealing with this response? Or
I've got no idea whether it was even in the tendering. I mean, this is from the codified agreement, and I never read this.
Could we look, please, at FUJ 401743?
Oh, yes.
So this is a service description for implementation and maintenance of security policy and procedures dated
Yes.
the 6th of January 2003. And in your statement, you say that, to the best of your belief, this document contained the first contractual requirement on Fujitsu to provide witness evidence in litigation.
Yes.
And again, I understand that's your knowledge now, but not at the time.
It's my knowledge now. Can I just amplify that? I never regarded PACE as necessarily requiring witness. It required a certification with the potentiality for a witness. But when I look at this, it seems to me different to PACE.
Well, at the time, did you have any awareness of
No,
PACE certification?
No. At the time, I didn't know about PACE. I mean, I've said that in my witness statement because I didn't read that schedule.
Can we turn, please, to page 17? And
Yeah, the litigation.
if you have litigation support,
Yes,
please.
yes.
So we see here that it refers to what Post Office submitting audit record queries or old fallback queries, essentially requests for ARQ data as we know it.
Yeah.
And it says, 1, to present the record of transactions, but B, subject to the limits set out below, analyse the appropriate Fujitsu Services help desk records and date range, branch non-polling reports for the branch in question, and fault logs for the devices
Yes.
from which the records of transactions were obtained. And then if we go down, thank you, we see request and allow the relevant employees of Fujitsu Services to prepare witness statements of fact in relation to that query.
Yes.
Now, this contractual agreement for Fujitsu employees to prepare witness evidence of fact as a contractual service being offered by ICL or Fujitsu Services Limited, do you consider that should have gone to the board to determine if it's something that ICL or Fujitsu Services Limited wanted to offer or should agree to offer? So it should agree to provide.
I think this is I think this is the most serious question of all, and it comes back to some of the things that I said in my witness statement. There was no requirement for this particular document to be approved by the board. If you look at the beginnings, I think it goes as far as Martin Bennett. When one looks at it by hindsight, and I'm not saying this to mitigate what I think, and I've said before, is a miscarriage of justice. It was not raised to the board. Should it have been raised to the board? I think the problem with this document is that the requirement for witness statements shouldn't have been dealt with by security personnel. And in the midst of a security document, should it have been raised to the board? It wasn't. What I say in hindsight is I wish it had, but that's hindsight. There are many issues that you could have raised to the board, but it was chose not to do so.
Would you accept that this contractual service that's being agreed in this document is outside of the normal course of business for Fujitsu?
No, I wouldn't. I think that's not Well, it's not our business to provide witnesses. Certainly we don't provide, or we didn't in my day, provide expert witnesses. That's absolutely true. When I looked at this, one of the problems, as I understand it, is, of course, that PACE was repealed in Section 69 was repealed.
I'll come back to the question, sorry, is
Yes.
what is being agreed here, the provision of witness statements by Fujitsu employees, is that outside of the normal course of Fujitsu's business at that time?
If it was only a witness statement of fact that this is a document that we've got off the computer, I wouldn't have thought so. I mean, I'm sure that that was something that happened in other contracts. I don't know. But as long as it was a statement of fact, I wouldn't particularly have had a problem with it. You know, this is the document, this is what I took off, there it is, make of it what you will, as long as it was fact.
So is it your evidence that if it's a witness statement of fact, you didn't think it needed to come to the board?
No, I wouldn't. If it was an expert, let me be clear about this. If somebody was saying we want a Fujitsu witness to be an expert witness, speaking about all sorts of things about the system, that was not something that we would have provided to a customer. We would have said, go and get an expert and get them to do it. So I don't think this is out of the ordinary course of business. But if you went beyond a statement of fact, here's the document, this is what I took off, and you can examine it with all the bits and pieces that are in the earlier section. But that's fact. Expert opinion, no. That definitely not. We're not in that business. That's what I think.
Well, when it says, looky here, it says subject to the limits below, analyse, so it's analysing fault logs for the devices from which the records of transactions were obtained in order to check the records of transactions extracted by that query.
In order
So
to
where
check the
there's
integrity of records.
integrity of records, where there's analysis of fault logs,
Well,
what's your view on that?
okay, I looked at this, and the fact that the fault log is there is a statement of fact. And when you look at it, you see that there are various faults, so you have to describe them. I think it's important to talk about checking the integrity of the records. You said this elsewhere in my statement, but in my view, integrity means uncorrupted, whole and complete, but it doesn't mean accurate, which is what we're coming down to, the question of whether there were discrepancies in the cash account. And I think this is the word that was used, integrity, earlier on when they were in these other system specifications, when they were talking about security. It's all about security, not tampered with.
You've heard, I understand you've listened to some of the evidence of the inquiry.
Some of them here, not all by any means, but I tried to prepare myself as best I could.
Have you heard, for example, of the Clark advice of the 15th of July 2013?
No, I'm sorry, I haven't, no.
Referring to Post Office's use of Gareth Jenkins as an expert witness.
Well, that surprises me, and it's not something that I would have expected Fujitsu to do.
If a Fujitsu employee was being used to provide expert evidence, my understanding is you think that something like that should have gone to the board.
Definitely, and I would have made sure in those, or me, but what I would expect is that expert witness would have been properly advised by an independent solicitor.
Can you explain why in this case, or in this time, the use of Fujitsu witnesses such as Gareth Jenkins wasn't raised at a board level?
As I've said, because when you say at this time, do you mean 2013?
No, sorry, I'm so sorry, at the time of this document, 2000.
Right. What I'm saying is I don't think that witness statements of fact would have been necessary, and I'm not critical of that. I'm very critical of the use of a Fujitsu employee as an expert witness if they're not properly advised by an independent legal counsel.
And can you offer a view on why that latter issue didn't come to the board of Fujitsu?
Well, I don't know when it started, so I can't tell you, but I suspect it's more ignorance than anything else. I doubt that the security people that you're talking here really understand the difference. Their mind is always on integrity, untampered with, not corrupted. It's not about being an expert witness.
Could we turn the page, please? It referred to limits,
Yes.
and we see at Roman 4 and Roman 5, there are Fujitsu service obligations in 1 and 2 above shall be limited in aggregate to dealing with a maximum of 150 in aggregate record queries.
Yes.
Have you, the inquiry's heard evidence about Fujitsu's remuneration in respect of witness evidence produced. Did you have any knowledge of that remuneration?
No.
The document can come down, thank you.
Well, just before we do, Mr. Stevens, I just want to be clear, Mr. Christou. One can haggle about the interpretation of contractual clauses. I would just like your help as a very senior person in Fujitsu as to two matters. First of all, in your opinion, and I stress in your opinion, does the clause that we just looked at, oblige Fujitsu to provide a witness to give opinion evidence?
No.
Right. So have you got any idea how it came to be, if it is the case, that from approximately the mid-2000s, that is around 2004, 2005, a Fujitsu employee, and we all know who it is, Mr. Jenkins, was making witness statements which included opinion evidence?
I do not know, sir. I do not know.
But I think you do agree with Mr. Stevens that such activity, if it were to be approved, should have been approved by the board.
I do, yes.
Fine, thank you.
The matters the chair was, to which the chair was just referring, who within your reporting line would have been responsible for oversight of this litigation support?
Martin Bennett, I think, is the correct one. I mean, he's a long way down because I don't know whether he was still there in that time, 2005.
And is in 2003, is the reporting line from either Martin Bennett or his replacement through David Courtley?
Yes, yes. Well, through the managing director of Pathway to Courtley to me, yes.
Could we please look at FUJ 403534? This is my last topic.
Yep.
These are actually draft minutes, but I want to take you to a part of them. It's on the 20th of August 2002, a meeting of the FSMC. Could we look at page 14, please? If we could go down to relationship with the UK government. Mr. Christie reported that the government was our biggest customer and it was essential that we had a good relationship with them. Renegotiating Libra had been very stressful. Just to pause there, that's nothing to do with the post office, I understand. Libra.
No, this is nothing to do with the post office at all.
And all the permanent secretaries were aware of the negotiations that had taken place. During the last year, we had again been a topic of conversation as the Pathway and HMCE contracts were being renegotiated. While these negotiations were ongoing, it was important not to be too friendly, or else we risk weakening our position. However, we were now able to build on relationships. Mr. Christou had visited all the permanent secretaries, and he had also joined them on a training weekend. Consequently, although there was room for improvement, we were on good terms with them, and they are, by and large, all satisfied with the service Fujitsu Services provide. When you say all the permanent secretaries there, is that every permanent secretary to each government department, or just those to which Fujitsu had contracted with?
No, I mean the ones that we were dealing with, yeah.
You go on to say, Mr. Christou added that the relationship with the DTI was good. He was having talks with representatives both in his capacity as a member of various DTI committees and also as a service provider.
Yeah.
How often did you meet with representatives of the Department for Trade and Industry?
Actually, quite often, because there were various fora. They used to get all the IT people together, for instance, and we met on numerous occasions. I had the minister's name of Patricia something in those days. I can't remember the last name, but I used to spend quite a lot of time with her.
Patricia Hewitt.
That's right, Patricia Hewitt. And there was the permanent secretary. I'm afraid I can't remember the name, but we used to visit them quite regularly because we had Elgar with them, which was a very large project.
At any point when you met with representatives of DTI, did you discuss the actual adequacy of the Horizon IT system?
No, it was never the topic of discussion. We were always talking about our contract with them.
From 2003 onwards, did you ever meet with representatives of the shareholder executive?
Could you be more, the shareholder?
Sorry, the shareholder executive, a government agency that managed the government shareholding interest in companies, including post office.
No, I didn't know anything about that. No.
Standing back, having examined the documents that you've seen today, do you consider there to have been, in your view, any relevant management failings within Fujitsu that was relevant to the prosecution of sub-postmasters?
I think the issue comes down to this question of, I'm sorry to keep on mentioning him, Gareth Jenkins, how he came to be an expert witness. And I can't answer that question, but I think that's the nub of it. I've always felt that it was the processes of information flow that led to the prosecutions that were the cause of the problem, rather than, if you like, bugs in the system itself. But I can't answer that.
So those are all the questions I have. Before I turn to see if there are any from core participants, do you have any questions?
No, I'm fine, thank you.
Ms. Page, Ms. Page, I think that's it. 5 or 10 minutes worth of questions.
Well, then, can we ask the shorthand writer whether she'd like a break before Miss Page asks questions, or whether she'd prefer to have a maximum of 10 minutes and then have a lunch break in effect?
Yes, sir. Yeah, we're fine to continue, sir.
Fine. Then, sorry to impose a 10-minute time limit on you, Ms. Page, but I think that's reasonably fair in the circumstances.
No difficulty at all, sir. Thank you very much. I want to ask you a few questions, please, about whistleblowing. The Bates litigation established as fact that there were bugs, errors and defects in the Horizon system. which could and did cause errors in post office branch accounts. Now, you don't appear to accept that that means that Fujitsu failed to deliver a product to post office, an accounting system that was fit for purpose, but nevertheless there might be those who do. Do you understand what I'm saying?
No,
there?
I understand where you're coming from. I mean, and what I'm saying is not to mitigate. I've said this before, but I'll say it again. I do not mitigate the seriousness of the miscarriage of justice. That's the first point. But the issue to me is, first of all, fitness for purpose was never part of the codified agreement. It was specifically excluded. What we did was to agree a specification, agree acceptance tests with the post office, and that was the basis of the contract. We accept, I accept now, having heard everything and the appeals against the cases, there were bugs. I don't believe that it was the bugs that caused the issue. The issue is that these discrepancies weren't properly presented in evidence. That's what I think. Why it happened, I'm not competent to say, but that's my view.
All right. Well, what I want to ask you about is Mr. David McDonnell, who gave evidence to this inquiry about the shockingly bad development of the EPOS code. And Mr. Stevens this morning has taken you to the documents dealing with how that was managed within Pathway, both in 1998 and in 2000. Now, I don't need to go back over what you've said already. You don't criticise the way that what you say the technical issue was managed. Nevertheless, at the time and subsequently, Mr. McDonnell was deeply critical of the way that that was managed. And he gave evidence about the fact that he was sidelined as a result, moved into a different role. So what I want to ask you about is what process was there for him to blow the whistle at the time? What process was there for him to take his concerns higher when the management of Pathway refused to accept what he was saying?
Well, in those days, there was certainly no whistleblowing procedure. That's the first thing, and I don't think people thought about it in those days. What I will say to you is that I never shut the door to my office. If he had felt sufficiently strongly, he could have come and seen me. That's all I can say. I don't actually know him, but if somebody had come and seen me, then I would have investigated. It might not have meant a different decision, but he didn't. So that's all I can tell you.
A different area, but still on whistleblowing. The inquiry has now seen ample evidence that Fujitsu support teams were effectively able to tamper with branch accounts without the sub-postmaster knowing. And that wasn't for a short period, that was over many, many years. So in effect, the security designs put in place just didn't stand up to the reality test. The support teams were given privileged access on what we've seen referred to as a needs-must basis. And that continued not only through your time, but also for many years subsequently, really all the way through until the group litigation. And it was really only the testimony of a Panorama whistleblower, who then became a whistleblower in the Bates litigation, Mr. Richard Roll, that actually started the process of finding out the truth. And obviously in all of that time, there were many employees within Fujitsu's support team who knew what was going on and knew about the ability to tamper with branch accounts, and indeed there were many concerns raised from the mid-2000s onwards about it. So again, why were there no Fujitsu whistleblowers? What happened? Why did nobody come forward?
Well, I'll make 2 points to you. First of all, I don't like the word tamper. That's a pejorative term. Secondly, my understanding is, and I knew nothing about this particularly at the time, that these alterations were made in conjunction with the Post Office in order to correct various issues. That's what
I saw coming out of the evidence. Why were there no whistleblowers coming forward? You'd have to ask the potential whistleblowers in Fujitsu. All I'm saying to you is nobody came to me and blew any whistles.
You don't take any responsibility.
No.
So you don't.
I'm not mitigating that there is a gross miscarriage of justice. And if you think I don't feel for the postmasters and the sub-postmasters, you're wrong. I do feel. And I also feel aggrieved that what I felt was a good system has been put into such disrepute. But I'm not responsible for it. And I've told you before, I'm sorry, I shouldn't say it like this, perhaps with more respect. I've said before that the real issue is the way the prosecutions were handled and the flows of information. Why there were no whistleblowers and what they would have told me if there were any, I don't know. And I'm sorry about that, but I can't help you further.
Let me just ask you this final question. When concerns first started to be raised about the possibility that Fujitsu could insert transactions, if you don't like tamper, that's what they were doing, could insert transactions into branch accounts without postmasters knowing. When those concerns first started to be raised, why was there no concerted effort by Fujitsu management to find out the truth?
I don't know when they were raised, and you're assuming that there was none, and you're insisting on the word tampered, so I'm afraid my answer is I don't know.
Thank you. Those are my questions, sir.
Thank you, Ms. Page. Is that it, Mr. Stevens?
Yes, sir, that's it. Yes, that's it from the core participants and Mr. Christie's evidence.
So, Mr. Christou, thank you very much for making two statements, written statements, that is, and for giving evidence to the inquiry this morning. I'm grateful to you. I think we'll now adjourn, shall we, and take our lunch break. So what time shall we resume?
1:30, please, sir.
Fine. All right, then. See you all.
Thank you, sir.
Thank you, sir.
Thank you.